Welcome to the Africa Construction Law Conference, North Africa Sub-Region. Please note the session is being recorded. All delegates are in a listen-only mode. If you'd like to ask a question, please use the Q&A function shown at the bottom right of your screen. We will try our best to answer these at the end. The icon to control your view is in the upper right-hand corner of this window. We recommend stage view for this webinar. I would like to introduce our first speaker today. Sakai, you have the floor.
Everyone to the inaugural launch of the Africa Construction Law, the ACL. My name is Sakai Nyambo, and I am one of the directors of the ACL, but I'm also an associate director with HKA. As you may well know, Africa Construction Law is a Pan-African initiative set up by construction law practitioners across Africa and in the diaspora as well, to promote thought leadership in the field of construction law and practice in Africa. The ACL has an advisory board made up of experienced and distinguished professionals in the field of construction law. And indeed, today we are grateful to have Aisha Nadar, one of the advisory board members, and it's a real pleasure to have her today. ACL is managed by a global steering committee made up of construction law practitioners and other professionals working in leading law firms and consultancies in Africa, in London, and the United Emirates. As of today, ACL has country coordinators in 20+ countries, including key African jurisdictions such as Egypt, Nigeria, Kenya, South Africa, and Morocco, but to mention a few. Our country coordinators are supported by a sub-regional coordinators and a board of directors. As ACL is launching this week, people may be asking the question, why is it important to have a construction law-focused initiative in Africa? The answer really lies in the steady rise of infrastructure projects in Africa, which have been driven firstly by the increase in direct foreign investment in the continent, including China. Secondly, African governments have prioritized the development of infrastructure projects in a bid to achieve regional integration triggered by the commencement of the African Continental Free Trade Agreement. Consequently, and going forward, the demand for construction law expertise is likely only to increase. Unfortunately, with the number of infrastructure projects rising within the continent, so too will the frequency of construction and engineering disputes. Regrettably, up to now, African arbitration practitioners have been sidelined in international arbitration, including construction disputes. For instance, the recent ICC statistics show that despite African countries representing 7.5%, that is nearly 188 parties of the total parties involved in the ICC arbitration cases filed in 2019. Can you believe only 3.6% of arbitrators appointed originated from Africa? This is a stark contrast to North and Western Europe, with 56.4% of arbitration appointments, and South and East Asia with 9% of arbitration appointments. This trend is equally true for participation as arbitration counsel in international construction disputes. One of the ACL's aims is to provide support to African practitioners so that more effective participation in international arbitration, and more particularly arbitrations involving African parties, is achieved. To achieve this objective, ACL would encourage construction law practice through capacity building and training. In the coming years ahead, we hope to embark on the following. We want to engage and share the ACL platform with young professionals seeking to practice law and specialize in this area. We want to promote all forms of ADR and to encourage and support the development of litigation and ADR support services, such as claims, delay, quantum, architectural and engineering expert witnesses in Africa. We want to contribute to the development of practitioners in Africa with construction law experience by providing a devoted forum for specific construction law training, engagement, and networking. Finally, we want to showcase those construction law practitioners within the continent that hold a wealth of construction law experience and share some experience throughout, share such experience throughout all of the ACL. In doing so, it is hoped that the pool from which African arbitrators can be shortlisted for arbitration appointment would be expanded and diversified. At the core of each of these objectives is ACL's mission to provide thought leadership in the field of construction law by contributing to the development of the law, policy and practices, including the use of dispute avoidance and resolution within the construction industry in Africa. ACL has already achieved Pan-African coordination and cooperation among construction law practitioners across the continent and is currently working collaboratively with law firms, with chambers and consultancies, with employers, with contractors and government authorities. ACL seeks to engage in research at regional level and collate data relevant to construction law and practice in Africa, including assisting African governments, entities and corporations in the area of capacity building and training in matters connected to construction law. So in doing so, it is hoped that it will be understood that construction law and practice across Africa is not and ought not to be broad brush in its application. Rather, there's much to be gained from insights shared by experienced practitioners from different African regions and indeed countries. So if you would like to be a part of this really, really exciting initiative, we would like to encourage you to reach out and join the ACL through the membership portal at the ACL website. If you are eligible, if you are interested, or if you are involved professionally in construction law, our members are coming from all sectors of the construction industry. So for example, we've got lawyers, we've got architects, we've got engineers, we've got surveyors, we've got contractors, developers, arbitrators, experts, anybody working within the field of construction law, you're all welcome to join. Therefore, on behalf of the advisory board and the board of directors of the ACL, I would like to thank you all for collaborating and supporting institutions who are amongst us, without which we would not be having this launch this week. I would also like to extend my thanks to all our advisory board members and our incredible board of directors who have worked tirelessly over the last few months in ensuring that this event is a success. I'm also grateful to all our sub-regional coordinators and our country coordinators who supported the ACL initiative right from day one and have worked tirelessly in ensuring the success of the event at the sub-regional levels. I want you to enjoy the conference today, and I want to thank you again for attending, and thank you very much. I will now like to introduce to you our first panel. Our first panel will be looking at transitional matters. And the moderator for the first panel is Aisha Nadar. She's a senior consultant working in Sweden, and she's actively involved in large-scale cross-border infrastructure and defense projects. She comes with a wealth of experience. She has handled all phases of negotiations and implementations. She advises clients on strategic procurement, planning, contract drafting, dispute resolution. She does it all. She's an arbitrator and a mediator, an adjudicator, and a dispute resolver. She's worked on FIDIC. She has experience in all forms of contract. But above all, I've had the pleasure of getting to know her just a little bit. And she's a wonderful person. So I'd like to pass over to Aisha, who will moderate our first panel. Thank you, Aisha.
Sakai, I am truly warmed by your very kind and gracious words of introduction. And I also thank you in getting to know you a little bit. I've also enjoyed that myself. And I really find your enthusiasm about the launch of this global event inspiring. And so we hope in our first panel that is going to be focused on transactions and contracts and putting the project together to focus on project success and to possibly help avoid dispute resolution. I am joined by two eminent speakers, which I am delighted and privileged to introduce. First, Colin Johnson. Colin is a partner with HKA, where he typically acts as an expert on damages, project viability, and project finance. His background, which led to this, includes working with the Commonwealth Development Corporation on projects in Asia, Africa, and Latin America. So he has quite a global footprint. He has acted as project developer, project investor, project lender, and project director. As part of his over 30 years experience, Colin has worked on matters relating to over half of all African countries. And I'm sure with an integral particular insight to our focus today on the North Africa region. So, and then we're also joined by Tim Armsby. Tim is a partner with the international law firm Pinsent Masons. He's based in Dubai, where he leads the firm's practice in finance and projects for the MENA region. Tim has been working on transactions in the MENA region for more than 20 years. He spent nearly 8 years in Cairo advising on energy and infrastructure projects. During that period, he played an important role in the development of PPP, working with the PPP central unit on a number of transactions. He's also advised across North Africa in countries that include Egypt, Libya, and Morocco. So without, and this is, I could go on about both of these gentlemen, but we may run out of time. So what I'd like to do is kind of set up how we want to focus on project success. We want, if we take a project from conception to completion, the upfront planning and in the investment in that upfront planning is the foundation of success or failure. As Sakai mentioned, I have some experience in the defense industry, and I was once told if you fail to plan, you plan to fail. So I'd like to start off by asking both Tim and Colin to kind of say, with your breadth of experience, what would you say are the top 3 areas that need focus to help ensure project success in the beginning? Tim?
Thank you, Aisha, for the introduction. It's a pleasure to be speaking today at this inaugural conference. Firstly, we should say, whilst the focus is on North Africa, it's quite difficult to make broad categorizations. It's a very diverse range of countries, and whilst the majority have a civil law legal system, there's significant variance from country to country. Some countries, for example, have a construction law, others don't. Even where there is a construction law, that tends to be based or focused more on matters such as licensing and the actual construction process, rather than creating a special regime either in relation to construction contracts or disputes. But I guess you can pull out certain themes. So payment issues, is a common problem. Delays in the construction schedule, cost overruns. In terms of the contracting approach, for traditional procurement, FIDIC is certainly the most common template that we see, albeit there tends to be a very employer focused approach. And I think we can also say that the sector is dominated by state-owned enterprises in terms of procuring these projects, at least outside the general real estate sector. Then, I guess, turning to your question, top three themes. I think for me, the number one would be project preparation. In terms of structuring these projects at the outset, I think a lot of issues flow from that. Secondly, risk allocation. I've already mentioned that, and this isn't common to North Africa at all, but the approach in contracting tends to be very employer friendly, and that often flows through to a combative approach on contract award. And lastly, I guess the procurement and contract management by the employer organisations, where there is often very little engagement or flexibility during procurement and into the implementation phase. So I think those would be my top three, appreciating we're not going to have time to discuss them all in detail on this session.
Yeah, no, I think we're just trying to, we could spend a whole conference discussing project preparation in North Africa, and we could spend a week in doing so. We have 35 minutes, so we're trying to provoke some thought and maybe raise more questions and provide answers, but things to think about in starting on the right foot for project success. So, Colin, what would be your top three areas that should be focused on to enhance success?
Thank you, Aisha. And thank you very much for the introduction, and thank you also to ACL for the invite to speak today. Looking at the three areas I would focus on, the first of those would be risk allocation. Tim's already talked on that to some extent, but it is key to ensure that we actually have the people best able to manage a risk actually dealing with it. Now, that's not always possible, but that's certainly, if we can achieve that, that will take us a long way towards ensuring successful projects. The second point, in terms of when Tim describes project preparation, I completely agree his point. And one of the things I would say as part of that is always have your view to the project financing. So the equity finance providers, but particularly the debt finance providers, who obviously are paid to take less risk and therefore generally make sure they minimize their risk to the absolute extent possible, understandably, will be going through the project with a fine-tooth comb in terms of the different areas that are of potential risk to them. And it's absolutely key from the outset to be thinking about what will concern the banks or the development finance institutions, so that that can be factored in now whilst it's easier to do so. I've seen, and I'm sure we've all seen, projects where some of these factors were not considered early on, and then once the banks come in and make entirely expected requests, suddenly there's efforts to renegotiate documents and so on that, had that been envisaged from the start, could have been dealt with earlier on. And that brings me to the third area I think is key, which is having the right level of experience in terms of people. You have to look at what the key areas are within the project. So when we're talking about a North African project, there is a lot that will be similar to other areas, other regions. But at the same time, as Tim said, each individual country very much has its own differences, and you need a blend of skills within your team that can manage the sector issues within the project, the country issues, and often the local issues as well, even right down to the exact place where a project is sited will be key. So those would be my top three.
Thank you, Tim. Thank you both, because I and thank you, Colin, because I see a lot of overlap and a lot of interesting segues to kind of probe a little further. I'd like to probe a little further with both of you, and I'll start with Tim, but I'll kind of pick up from where Colin left off, talking about customizing and localizing to get it right. And Colin was using that from getting the right people. But Tim, can I ask you to look a little further on preparing a project well, and what that does that? I mean, obviously there's a global thing, but with a focus on, with all your experience in North Africa, are there special considerations, or is there takeaways, advice, do's and don'ts that you might want to share?
Yes, well, I mean, I think in terms of project preparation, the reality is often little time is allowed for this. So what commonly happens is projects are being put to the market really at an earlier stage than they should be, and that in turn leads to a variety of events which is not in any party's interest. So you will often find that the procurement schedule stretches out much longer than expected. You may find that the poor preparation has an impact on market interest, so you don't get the level of competition that perhaps the transaction deserves, and then obviously going into the contract phase, if the necessary due diligence and preparation has not been carried out, there's a greater risk of delay, cost overruns, and disputes arising at that phase as well. Now, why is that? I think there are a variety of reasons. I think the first really is schedule. So in my experience, and that's working both for the public sector procuring projects and the private sector bidding for them, At a certain point in time, a decision is made that, right, we need a particular asset. There will then be a decision on how that asset's going to be procured. So design and build, EPC, or even PPP, so using private sector finance. But once the decision's been made, there is usually some urgency to demonstrate that project has been tendered and you can make an award. And often that flows from the decision-making process. So you find quite commonly there's actually little delegation and little willingness to tell those at a higher level that it's an unrealistic timetable, and really those conversations don't happen until you hit a real logjam. The other aspect, I think, is budget. So we're generally talking about countries which have constrained budgets, at least when you look at the public sector. Appreciate there are privately driven projects as well, but that again has an impact on the team. Both the capacity to deal with the tendering and perhaps the experience, and those come together with an unrealistic timetable and lead to poor project preparation. I guess the other aspect which we're seeing increasingly as well across the African region is more and more countries looking to use project finance and PPP, and those projects do require a lot more preparation than a traditional procurement. And there's I guess an additional step here in that at a certain point, government body needs to have a process by which, if they identify a need for new infrastructure, at what point do they decide if they're going to take traditional procurement or PPP as a route? And again, in terms of when they want that asset available, that decision was probably made earlier and is probably largely unachievable at the point it was made. So I've experienced this myself recently on a government mandate we have, where we were told to bid for a full PPP procurement, and the client expected that from the time of our appointment through to financial close would take 9 months. Now, I mean, I've been on projects where from the point of contract award to financial close, it's taken longer than 9 months. So clearly you've got, an inexperienced client who's been given a deadline. So they've squeezed everything in to achieve that deadline, but that's where the problems start, unfortunately.
We've all experienced just kind of pushing everything, there's a firm dead date, and because your commander told you that's what happens, and then you move everything to the right and you stack up stuff unrealistically. It looks okay on paper, but it's absolutely a non-starter for project preparation. And it's, I think if you compare the time in project preparation or the time it takes to understand your finances. And one of the things that Tim was talking about, many of the procuring agencies or the employers are state-owned enterprises. They're constrained financially. And Colin, you mentioned risk allocation. And I'd like to, maybe I'm kind of thinking, if you're constrained financially and you're a state-owned entity, shedding risk might not be the best way to get best value for money, possibly. Can you give us an idea of how to deal with risk in the upfront planning?
It's a key challenge, as you say, in terms of that balancing of the risk. So if I pick up what you've said in terms of the state-owned entity, it may not have too much money to actually sort of pass on the risks to somebody else and pay for them. However, at the same time, and this comes back to where you have to think about your financing up front, if that project is to be financed by even by the DFIs, the development finance institutions, you know, the World Bank and the African Development Bank and the EIB and others, but even more so if it's commercial banks, they will be seeking to ensure that those risks are covered by somebody who will be able to pay whatever is necessary at the time they occur. So the challenge is that if a government agency seeks to accept greater risk because they recognize that if they pass further risk on, there's a greater cost, that also may make the financing more difficult. So it is that constant balancing act between all of these. You know, it's exactly the same sort of issue with the construction. You know, when you look at the construction allocation of risk, obviously we can talk about a turnkey contract. And for anybody who's not familiar with that, you know, where basically the idea is that the work is pretty much all done by the contractor, so that literally the new owner can turn the key and it starts. That's at least the theory. Obviously, in practice, we know nothing is quite that simple. But the point is that when you've got that question as to who takes what risks in relation to the construction, who takes the risk of gaining the permits and actually bringing those together, who takes the risk of cost overruns, who takes the risk of those schedule delays, that's where there is that key necessity early on to think through all of these different issues. Because if, as I said, if you don't, the banks when they come in will, and that's when you suddenly find a project. You know, Tim talked about a market interest window. I think he didn't use the term window, but there's a time for each project. You know, if you've gone a long way down the road and then people find that you haven't considered all of these issues in the right way, you didn't do that upfront preparation, you didn't consider the risk allocation in detail, then I think from there, that's where you will start to lose market interest, because banks and others will pick up on that lack of experience that Tim talked about. And whilst we can talk about the contracts and we can talk about the different structures, the people who will be putting the money in, whether it's equity or debt, want to know that those that are actually delivering the project can do so, and really generally have done so previously. So that's also where that's key to keep in. But I'll stop because I know you may want to pick up other points. You're on mute, sorry.
I'd like to, thank you. I'd like to invite Tim to talk, you know, because project preparation really can't be extricated from risk allocation. So do you have some thoughts on to follow up what Colin said?
Yes, well, I mean, I think clearly a key part of the project preparation phase is understanding, at least at a basic level, the nature of the asset you're looking to build, the risks associated with that, and then considering an appropriate risk allocation. And you know, Colin's touched on this, but you know, generally we're looking at which party is best placed to manage a particular risk, and that will, you know, whilst there are general themes that you see in contracting approaches. It will vary from country to country and project to project within that country, depending on the particular nature of the site and the asset that you are looking to build. And I think, from my experience, again, the challenge here is we are working in regions where, for whatever reason, there has generally been a desire to maximize risk transfer, regardless of whether the contractor is best placed to manage that, coupled with a combative contracting approach once the contracts have been signed, which in a way goes completely against the philosophy of at least the newer versions of the FIDIC suite of contracts, where trying to find a reasonable approach so that the parties work to a degree collaboratively to produce an end result that's satisfactory. Now, again, I think the decision-making process is a challenge here, because it can be very difficult for government bodies to move away from their established precedent, even in circumstances where they've had a bad experience, with that on previous projects. I've encountered scenarios where, even with good advisors on board, DFIs and multinationals, the end client has resisted their advice and gone to market with poor or unreasonable, rather, risk allocation. I've even encountered a scenario where I've had advisors to procuring authorities effectively asking bidders to raise these issues in a clearer way as possible, to try and help the client come to the right decision, because they recognize, as Colin's mentioned, once you get to the phase where you have to finance these projects and they're looked at independently by lenders, the position will have to change. But changing it at that stage will cause delay and likely have a negative cost impact. So I think that that's the key message I guess we would like any employer, be it private or state sector, to understand, that yes, you might from one perspective want to maximize risk transfer, and that's understandable, but you have to bear in mind, if it's unreasonable, there will certainly be a cost to it, but it's likely to cause problems during the implementation phase as well.
Yeah, I think it's clear that if you don't plan and you don't do things right up front, you're going to have to pay to fix them as you go along, and it may be too late. You may lose credibility in the marketplace to get the right type of quality finance that you're looking for, and it will. I think you said something, Tim, that resonated with me. You create this combative atmosphere from the word go. So you're not starting with collaboration and cooperation to build a successful project. And that should be the objective, that everybody's in it to win it. Everybody's on the same team, right? If the project succeeds, everybody will succeed. If the project fails, everybody will fail. So it needs to be a collaborative thought process.
That's right.
Sorry, yeah, it's.
Well, I was going to, to give you an example of that. There's a mass transit project that I've worked on, and so obviously with a rail project, you're going through various sites, it's impossible to do, or very expensive to do a very detailed site survey for the full length of that site. But the procuring authority on that particular project sought to pass full site risk to the contractor, which unfortunately, you have to look at the contractors as well, because it's obviously been a tough market over the last decade, probably. So everyone wants a job, and as a result of that, often there's reluctance to raise issues and be firm on your position, and they came across a unknown underground cavern, and the route couldn't be changed. So the only way to deal with that was to try and fill this almost bottomless pit, and that caused significant delay. It almost caused the insolvency of the contractor as well, which would have been a disaster. And it's not something you can price for, unfortunately, but it gives you an indication of where notionally risk transfer was passed to the contractor, but they had no means of managing it.
Yeah, I mean, it's woe is the contractor that accepts it, and woe is the employer that accepts the contractor that accepts it. But what I'd like to do is maybe give an opportunity, if any of the participants have any questions for Tim or Colin, could you please pass them through in the Q&A? We'd be happy to address in the next few minutes that we have with you today. But I'd like to just kind of take on, let's say we plan the project right, and if we don't have any questions, I'll throw out a question to both of you. We planned the project right, we did the right risk allocation, and you both talked about the management of the procurement and the management of the contract and having the right people. Colin, can I invite you to talk about the criticality of post-contract award, even after planning?
It absolutely doesn't stop, as you say, with planning, and as you well know. That team must be in place and must be working right through the contract, because having the right contracts and having the right risk allocation is only the start of the process. What you then have to do is to ensure that those are delivered. So that contract management piece is absolutely critical. And this is where it comes back to having the people that are aware of that contract, are thinking ahead in terms of what's coming next. Are we preparing now for what's got to be dealt with? If we are going to want to start actual construction on the site within the next couple of months, do we have all the permits in place? Do we have the off-takers? Who's actually going to take what we produce? So it's that point about having the people that are thinking through that all the time, and sort of regularly as a project, actually meeting to sort of check where are the risks, what have we got to address, what's still got to be dealt with going forward now.
Tim, can I ask you to comment briefly?
Yeah. So I think two issues kind of come to mind there. I suppose we've got the, I think this is often aggravated by a budgeting perspective, particularly where you have a procuring entity that's a government body. So what you tend to find is, unless that particular entity has a constant flow of projects, it often falls on existing staff who have a day job to manage the procurement and contract phase, and that that means they may not have sufficient time, and it may also mean they don't have sufficient experience, and I think that's more aggravated for PPP projects where you're talking about complicated long-term contracts, and the actual contract management phase often doesn't get considered until you've actually put pen to paper, whereas it should be part of the upfront process of looking at the feasibility of the project, and budgeting to ensure you can either recruit, train, or otherwise ensure you've got suitably experienced resource internally to manage those contracts. And then I suppose the other aspect worth noting is the lack of an independent body on many of these projects. So even for traditional procurement, there generally be a mechanism or an appointment of some form of independent engineer, but the reality is rarely is that an independent appointment. It's just the eyes and ears of the employer, and they do as directed. They're not it's just an additional interface rather than anyone who's actually adding any layer of independence to the process. So that's another flaw in the contracting approach. And I guess what an interesting angle that perhaps changes that slightly, which Colin's touched on as well, is the use of external finance. So clearly, with the PPP, there is always external finance and a great degree of due diligence. So that kind of always happens. But with traditional procurement, particularly with budget constraints, you're increasingly seeing the use of contractor finance, and organisations like UK Export Finance and other ECAs increasingly active in the African region. And again, that provides through the use of the banks, some oversight in terms of ensuring that the processes are adequate to avoid dispute and avoid delay.
I think with avoiding disputes, I think we're going to have to close our session. We have to hand it over to the dispute section of the panel. And it is with absolute pleasure that I want you to join me in thanking Colin and Tim for their very thoughtful comments. And I hope that we can continue this type of thought process, Sakai, and engagement, because this can go on. And I think sharing these lessons learned are part of the ethos of African construction law and creating that thought leadership. So Sakai, back to you.
Indeed, thank you so much. Thank you, Tim, Colin, Aisha, for that exciting discussion and your thoughts and your views that you deem necessary, and what you deem necessary in terms of project transaction to ensure successful projects. There is so much for us to learn. You've given us all food for thought. And if our attendees have any queries on any of the matters that were raised in this discussion by Tim and Colin and Aisha, please do not hesitate to contact us on info@africaconstructionlaw.org. Or if you have their contact email addresses and you want to email them directly, I'm sure they wouldn't mind. I've said that with permission, I hope. But anyway, you're more than welcome. It is now my pleasure to introduce to you the second panel that will be looking at claims and dispute resolution. It is my pleasure to introduce Simon Longley, who is a principal and external consultant with HKA, and Simon will be our moderator. Just to give you a little bit of background on Simon, he's a chartered surveyor. He's also a legally qualified practitioner and arbitrator, and has more than 30 years experience in contracts, in claims and dispute management on large civil engineering and infrastructure projects and transport and power projects in the United Kingdom and internationally. He is somebody with a wealth of experience, and he regularly speaks and is a presenter at conferences and seminars. He's an accredited trainer. So basically we have an individual here who is packed with experience. And so I would like to pass over this section to Simon, who will in turn introduce the panel members for this next session. Thank you.
Well, thank you, Sakara, and thank you for the flattering words. Yeah, this second session is quite topical in terms of it's dealing with claims and disputes, which I guess most people will come across at some point in terms of their working lives on construction projects. We have 4 preeminent claims and dispute resolution specialists joining me on the panel today, and I'll just quickly introduce those because we've got quite a lot of interesting questions we'd like to deal with in the remaining time available. First of all is Trevor Powers, who's the director of HKA based in the UK. Trevor is a quantum expert and project manager with over 40 years of experience in the construction and engineering industries. He has authored expert reports and has been cross-examined in arbitration proceedings, and he's worked on major projects across the globe, including Africa, America, the UK and elsewhere. His experience includes commercial management and the managing of disputes, arbitrations and adjudications, and is therefore well versed in the claims and disputes environment. Secondly, we have Rob Wilkins, who's a partner at Pinsent Masons based in London, UK. Rob specialises in the management and resolution of disputes arising out of major international infrastructure and energy projects, with a particular focus on Africa. He has over 20 years experience in conducting international investment and commercial arbitrations, and has been described as an absolute guru of Africa-related arbitrations. Rob advises and represents owners, contractors and states in dispute resolution proceedings, including investment treaty arbitrations. Thirdly, we have Ibrahim Shahata, is a partner and head of the international arbitration practice at Shahata and Partners law firm based in Cairo, Egypt. Ibrahim has extensive experience in international commercial arbitrations, arbitration-related litigation, and complex banking and finance litigation. Ibrahim regularly represents clients in the construction and renewable energy sectors in the Middle East and across the African continent. In addition, Ibrahim is a regular contributor of articles in the field of international arbitration and is currently in the process of publishing the first English language treatise on arbitration in Egypt. And last but by no means least is Dr. Ismail Salim, who is the director of the Cairo Regional Centre for International Commercial Arbitration. He's also Secretary Treasurer of the International Federation of Commercial Arbitration Institutions and Vice President of the Egypt branch of the Chartered Institute of Arbitrators. In addition, Dr. Ismail maintains a practice as legal counsel arbitrator and is often appointed to provide expert opinions on Egyptian and Libyan laws in international proceedings. Like Ibrahim, Dr. Salim is a regular contributor of articles to international law publications, is a regular speaker at conferences, and is also a lecturer of law. So welcome to you all. So we have got a number of questions we'd like to cover in the time. So without further ado, I'll kick off with those questions. But again, to people listening in, if you do have any questions, please raise them in the chat box and we look to try and deal with those at the end of this session. So Trevor, if I may start with you, looking at a couple of claims issues. One that I think probably everyone's experienced at some point in time is the defence of time bar being raised against claims raised by contractors. What should contractors be doing to avoid otherwise potentially meritorious claims being rejected on the grounds of time bar?
Okay, right. Yeah, thank you, Simon. Yes, I mean, this is a very common problem we see with particularly on viewing from the contractor side about issuing the correct notices under the contract. Most contracts, well, virtually all contracts, including FIDIC particularly, there are requirements to issue notices if there is a delay to the project, which is outside of, or could be within the control of the contractor, but typically outside of the contractor. He has the responsibility to issue a notification or a notice to the client or the client's representative to ensure that that potential event is flagged up to the client, because then if that, for example, is an event which is within the control of the client or within his influence, then he could potentially minimize the impact of that event. So our recommendation always to contractors is issue notices as soon as possible. Most contracts include words such as soon as you become aware of an issue, you are responsible to issue that notice to your client. And also you have to ensure that you comply with the contract in terms of the form of that notice. Some contracts are very specific in the form that notice has to be issued, including the grounds for your notice, etc., and who the notice has to be issued to. I've worked on many cases where the contractor has said, well, we told the client at this particular meeting or this particular event that this was an issue, and it was recorded in the minutes, and then they can run into issues. I also found, working with a lot of international contractors, there can be a cultural issue of they don't want to flag to their client that they have a particular problem. And they say, oh, we're going to sort this out. But my recommendation always is to them is to issue your notice, record the potential event. There also may be, so when we talk about the actual time barring of these notices, some contracts are very specific. So for example, in the standard FIDIC terms, it's normally 28 days. So if an event occurs and the contractor does not notify within 28 days, then he runs the risk that that event will not be considered as an event that has to be compensated for in terms of an extension of time or additional costs. So they are the main things to consider. It can be more obviously complex in terms of in recent events such as COVID. I mean, everybody knew that COVID had sort of started as a virus in China. Well, we assume it's in China, but in late 2019. And would you have known as a contractor working, I don't know, in North Africa, that that event could impact upon your project? And would you have known that that would have the virus would have spread across the whole of Europe and the whole of the world, causing huge impact on projects, including delivery of materials, the availability for workforces and to move freely around countries, etc. So they're the main things, because if as in most contracts, no issue of notices often becomes a condition precedent in terms of making a claim to your client. So yes, I could go into more detail. There are some recent case law, particularly in Europe. There's the OHL, the Spanish EPC contractor against the government of Gibraltar, has become a very topical subject regarding time barring and notices. But I think I'll leave it there, Simon. And
okay, thank you, Trevor. So effectively, the message is it's in the contract, so comply with the contract. And I guess you say, if in doubt, put a notice in and hopefully avoid any defensive time bar. But obviously we know time bar is regularly raised by employers and engineers and employers' representatives, and we know that contractors are not the most always diligent of complying with timescales. So in terms of potential ways for a contractor to seek to defeat the time bar defence, what options are available, particularly under civil law jurisdictions? And in this respect, maybe Dr. Ismail, you may be able to provide some insight.
Yes, thank you, Simon. Well, it depends how we do characterize these types of time bar clauses in the contracts. There are several doctrines, and I can also provide you with what the Court of Cassation of Egypt has decided with this respect. One of the prevailing characterization would be to characterize the obligation on the employer that would arise from the claims made by the contractor being a conditional obligation. In civil law, an obligation and a right are the two faces of the same coin. So we can speak on a conditional obligation, which is from the other side's perspective, and a conditional right. So an obligation is conditional when its existence and or its extinction depends on a future or uncertain event. So the person who would be undertaking the obligation here would be the employer. For example, the employer's obligation to pay, to make additional payments, or from the other side of the coin, the contractor's right to receive additional payment or to benefit or enjoy an extension of time. So here, the condition one of the conditions of such right or obligation would be that the contractor complies with the time limits for making his or her claim or its claim. So this characterization would be more or less restrictive, and the contractor would have to comply with the time limits. Of course, all will depend on the wording of each clause. In civil law, we have the doctrines of obligation de moyens et obligation de résultat. Obligation de moyens, it's an obligation to exercise care. Obligation de résultat, we have to achieve a certain result. So here, the time limit should be complied with and respected. There are other characterizations of the issue. It has been characterized as an attempt to modify the statutory time limits, which are mandatory or public or pertaining to public policy, and thus declared null and void. We have seen very few awards resorting to such interpretation. So this is another interpretation with which I do not agree. I do not see it as an attempt to amend statutory time limits for the extinction of a right. There are also some engineers or some arbitrators having an engineering background who have invoked theories like abuse of right and good faith, with an attempt to try to mitigate the effect of such time bar provisions. There is also some decisions. There are also some decisions of the Court of Cassation of Egypt, whereby if the employer is aware of the possible increase or decrease of quantities, and thus the notice in this case will not be a condition precedent to payment. So the awareness or the knowledge of the employer would replace the strict obligation to make a notice within a time limit. This is one of the approaches, or an approach by the Egyptian Court of Cassation. Thank you.
Okay, thank you very much, Dr. Ismail. Ibrahim, is there anything else you'd like to add in terms of civil law potential challenges to time bar defences?
I think Dr. Ismail has covered most of it. What I see in practice is that sometimes it's not a FedEx contract. That's sometimes the case in Egyptian, construction cases, and there's just like a clause that says that you should deliver the notice within a reasonable time, without setting like a 28-day limit or other like certain restrictive day limits. So this is something that I guess would be a little bit different when interpreted in Egypt or civil law jurisdictions than in common law jurisdictions, because you have to go to the mutual intention of the parties and see how they perform the contract and what would be reasonable in the eyes of the contracting parties. It could be more than the 28-day limit, and also parties could take advantage of the cassation precedent Dr. Ismail mentioned, that if the employer already knows that there's something wrong, then there might not be a need for a notice in specific. So yeah, that's my take on this point.
Okay, so in terms of time bars, then it sounds as though in terms of civil law jurisdictions, there are opportunities and available to challenge the striking down of a claim on time bar. But again, I guess that the key message is comply with the contract first up, and then you avoid all those potential legal arguments that may or may not be successful, and obviously the time and cost of trying to pursue a claim that is, say, subject to a proper notice would have been able to be passed up the line straight away. Okay, well, that was very useful. Thank you, gentlemen. I'm now going to turn to Rob, maybe to set scene some of the common causes of construction claims in the region, and also the impact that COVID-19 has had on, if you like, construction contracts, and how, if you like, the contract administration side has been impacted. Rob, would you like to kick off on that one?
Thank you, Simon. That's a really interesting question. We've heard at the top of the session today from Sakai and also from Tim that this is a complex, the answer to that question is pretty complex. It involves consideration of a number of factors: economic, political, project and contract issues. We heard about the incorrect allocation of risk, and the impact that can have. There'll also be drivers in different jurisdictions, as Tim alluded to. And in taking North Africa, there's an obvious split between the resource-dependent economies in North Africa and those that are less affected by the fluctuations, for example, in the oil price. Thankfully, there are some studies which help us get a better handle on things. The St Mason's Queen Mary University study, whose results were published before COVID impacted, was looking primarily at efficiency in construction arbitration, but it also canvassed the views of respondents on the three most common causes. And they were found to be, perhaps unsurprisingly, late performance, poor contract management, as again has been alluded to before, and that was followed by poor contract drafting. Now, that wasn't looking regionally, and whilst additional risks might be present in the region that we're looking at today, perhaps in the context of some challenging physical environments and perhaps some other political and economic issues, I think those same drivers would probably hold good for North Africa. And also the HKA Crux Insight report, which you'll be familiar with, that looked at drivers for construction claims as well, came at it from a slightly different methodology. But helpfully that report looked at the regions as well. And whilst North Africa was dealt with as part of the wider African continent and the Middle East, the primary causes of claims and disputes that was identified in that report were found to be similar. And from a North African or an African perspective, the top three were change in scope, issues with design, as well as, again, the contract drafting, interpretation and poor contract management, which I've put together. And I think when discussing the region as well, we ought to just, it's worth mentioning as well the Arab Spring and the claims that were commenced on the back of that, and they're still working their way through even today, over 10 years on. So that's the sort of pre-COVID historic picture, if you like. They're the underlying causes of construction claims that we've seen. But obviously the COVID-19's had a significant impact on projects in the construction sector, and we're in a very different set of circumstances today than we were a year or so ago. COVID's had a direct impact through the physical closure of sites, impact on global supply chains, the deferment and cancellation of projects. And there's also been a sort of more subtle impact, if you like, in terms of refocusing within the industry in terms of reducing capital expenditure and managing cash flow. And I think the fallout from COVID has seen a sort of accentuation of some of the issues that were there before, and that has perhaps led to some more claims. Now, unsurprisingly, when COVID first hit, one of the most common issues we were asked to look at and to advise on was the applicability of force majeure provisions in the contracts that were affected, and whether the parties affected were able to claim relief from performance. Now, most force majeure clauses, including FIDIC that we've heard is very prevalent in the region, operate to suspend the obligation to perform when a qualifying event has occurred. Now, whilst performance is excused and extensions of time are often given to cover that impact, it doesn't necessarily mean that the impacted party is entitled to claim costs or indeed loss and expense unless that's expressly provided for in the contract. So we were also experiencing inquiries looking at alternative ways of claiming due to the pandemic, for example, whether action by government might constitute a change in law which would allow a party to claim money as well as time under their contract. Now, I'm coming at this as a common law lawyer, and whilst the consequences of force majeure on any given project will usually depend on the contractual provisions or the terms of the contract in question. In common law jurisdictions, if there's no force majeure provision, or if you don't find yourself within the sort of four corners of that, or the definition of that provision, then that will usually be the end of the story, and the party's only option then would be to look at some narrower legal principles such as frustration, which might apply but are quite difficult to fit in. But as we know, civil code jurisdictions come at this slightly differently, and many of the North African jurisdictions that we're looking at today will have force majeure as a recognised legal concept, and that will often be enshrined in the relevant civil code, which will make express provision for it, such that parties might be able to rely on force majeure even if the contract is silent or not available to them. And I'm not going to go any further than that because we've got two very distinguished and experienced civil code practitioners on the call today. But just to mention that, and then just to wrap up, as the pandemic has gone on, we've seen increasing inquiries around suspension, given advice around suspension, even the termination of contracts, as parties seek to extricate themselves from contracts that are no longer viable. And just finally, whilst these may not really be working their way through just yet, I think there's also some potential to see an increase in claims by investors in the construction sector against host states under relevant bilateral and multilateral investment treaties in consequence of actions taken or in fact not taken by host states connected with the pandemic. So that's just a very quick run through of pre and post COVID drivers for disputes, and I think if we were to rerun some of those surveys and reports today, we'd get a very different answer.
Yeah, okay, thanks, Rob. That was very, very useful and very informative. Just picking up on your point about obviously civil law jurisdictions and force majeure, Ibrahim, is there anything you'd like to add to that in terms of any particular slant or approach that may be open in civil laws jurisdictions?
So, yeah, for sure. When we talk about COVID-19, we talk about an event that might have different applications depending on the construction site, depending on the construction project, and depending on where it is exactly. And there's no one size fits all. So what might be considered a sort of an impossibility to continue performing the contract in one situation might not be the same in another situation. So if it is impossible to continue performing the contract, which is something that we didn't see in COVID-19, to be honest, especially here in Egypt, maybe in other countries, it was impossible for a certain time period, but it was not like, completely impossible for good. So if that's the case, then by operation of law, then the contract would be terminated by operation of law, and the parties would have to go to the situation where they were at before the contract was drafted or concluded. But in any case, the civil code in Egypt permits the parties to have an agreement on how the consequences of force majeure will be allocated. So it is something that the parties can agree to. And sometimes there is a misconception about another similar theory, which is the exceptional circumstances theory. Some people or some practitioners think that it is a public policy rule. What is public policy or what is mandatory in it is that it has to be reviewed by the arbitral tribunal or the judge, but it doesn't mean that it has to be applied in every time. So it is subject to the discretion of the arbitral tribunal to see if there is actually an onerous situation which should call for a reallocation of the project. And when is that done, it doesn't mean that the party goes to the same position that it was at, to be completely profitable. It means to separate the losses, to make it practical to continue the project, to make it possible to continue the project. So that's these are the key provisions under the Egyptian Civil Code that might interact with the operation of the contract in Egypt. And as you know, Egypt is the Sangheirian Code is the father or the parent code of many civil codes in the Arab world.
Okay, thank you, Abraham. Okay, and obviously it's a subject that can be talked on extensively, but we do have a number of other topics. So let's move on to the next one. And again, Rob, if I can come to you, in terms of typical dispute fora for resolving claims and disputes in construction contracts in Africa, can you just sort of outline in your experience what those are?
Sure, thanks again, Simon. I think the starting point is the contract, and the answer will usually be found there. Tiered dispute resolution provisions are a common feature of construction contracts, and as we see in FIDIC, which, as we've mentioned, is prevalent in the region. And these clauses effectively require the parties to go through various stages before they can get to what might be termed the final means of dispute resolution. And depending on the contract, it may be an engineer's decision, an obligation to negotiate, dispute review boards and dispute adjudication boards, and they we're going to come on to look at. But once you've been through those stages, or if there are no preconditions, you can go straight to the final means of dispute resolution. And in the context of international construction contracts, international arbitration is very much the preferred method of final dispute resolution. I'm sure everyone this webinar is aware, but arbitration is a private, non-court alternative to resolving disputes, where an arbitrator or panel of arbitrators will be appointed to make a binding decision, and that decision is subject to only very limited grounds for challenge in usual circumstances. Now, that's a global trend. Again, we're seeing as well a significant increase in the use of international arbitration to resolve disputes on African projects. The Crux report that I mentioned earlier identified that arbitration accounted for 33% of disputes in the wider region. Again, that's Africa and the Middle East, compared to only 9% being resolved finally by litigation. And I think there are a number of reasons for this. Typically, the fact that the process is confidential and can minimise any potential reputational damage, the flexibility that the parties effectively get to choose the process and have their dispute settled by experienced and appropriately qualified arbitrators who they have a hand in selecting. And finally, I think this is particularly relevant in a region such as North Africa, where we've heard that many of the majority of the projects have a state involvement, and where you're an international contractor going to one of those jurisdictions, there's a real reluctance, I think, on the part of international contractors to submit to the jurisdiction of local courts. For all of those reasons and others, construction contracts with an international element in the region are likely to include an arbitration clause specifying arbitration as the final resolution process. Just very quickly on the arbitration clause, they will typically include a number of key elements. The language of the arbitration rather, the number of arbitrators, whether it's one arbitrator or panel of three, and how that may be put together, any rules that are going to be followed, any institutional rules, the seat of the arbitration, which is the sort of the legal place of the arbitration, which is important as it determines the procedural law that will apply, and also be relevant to the issue of enforcement, which again we'll come on to talk about later on. And also a recent case in England suggests that arbitration agreements also ought to be including a specification of the law governing the arbitration agreement itself, because they're generally severable from the underlying contract. The arbitration agreement might specify an institution to administer the arbitration, or the arbitration might be ad hoc. Perhaps unsurprisingly, data for ad hoc arbitrations is a little harder to come by. But the primacy of international arbitrations as a means of dispute resolution can be seen from the ICC statistics recently released for 2019, which Sakai mentioned at the start of this webinar. And they showed that around, I think, nearly 900 cases, 40% were generated in the construction and energy sectors. And again, Sakai mentioned that the fact that 7.5% of all of those cases involved African parties, and there was a strong representation there from North African parties, Egypt, Algeria, and Morocco among them. Now, whilst the ICC is the most popular forum for major Africa-related arbitrations, there are many. There's a bit of a drive really with African counterparties, typically state-owned entities, increasingly attempting to avoid the traditional arbitration institution and opting for their own or for regional arbitration centres, or where ICC and LCI arbitrations are occurring for those to be seated in their home jurisdiction, or at least in a compromise venue that's deemed to be more neutral. And there's a recent SOAS survey in 2020 which listed the top 5 arbitral centres in Africa, and Dr. Salim will be pleased and will be very well aware that his institution, Kersika, ranked very highly in that, and he'll be able to tell us more, I'm sure, about the successes he's achieved in developing Kersika as a really viable alternative to those more traditional arbitration institutions and centres. So I'll perhaps leave it there and let others talk about the sort of African regional centres.
Okay, thanks, Rob. I mean, just a quick question in terms of the percentage of arbitrations in Africa is proportionately higher than elsewhere. Do you think that's more to do with the fact that contracting parties in Africa are less aware of other forms of ADR, or that it's just that it's arbitration it provides in theory a final result and therefore they're happier to go all the way?
It's a very good question. I don't think it's a lack of awareness. I think parties are generally well informed and often legally represented, so that there will be an awareness of other forms. And as I say, we're talking here about a final dispute resolution mechanism. So this really comes down to a choice between local courts or international arbitration. And for the reasons I've mentioned, that there is generally a reluctance for international contractors to submit to the jurisdiction of the local courts. That there's a perception that perhaps they're not well set up to deal with what are often complex construction disputes. There may be a fear of perceived home advantage and just the difficulties of pursuing a state in their home court. But certainly many of the contracts that we see, the FIDIC form and others, will require the parties to go through the sort of steps that I mentioned at the top of my answer, and whether that is as part of a contractual process or indeed in parallel to more formal dispute resolution proceedings. I mean, we always advise our clients to explore amicable settlement, whether that's informal or through a more formal process such as mediation. So I think it's quite a complex situation, but I think what we're seeing in those statistics is really a choice between the court of one or other of the parties and international arbitration, and I think unsurprisingly, when that's the choice, international arbitration comes out rather well.
Okay, thanks, Rob. Trevor, quickly turning to you in terms of dispute boards. We know have been a standard feature of FIDIC contracts for a number of years, and obviously FIDIC contracts are quite well used in Africa. What's your views in terms of the benefits to contracting parties of using a dispute board and there's the potential for finally resolving issues?
Yes, yes, thanks, Simon. The use of, as you say, DABs, dispute adjudication boards, is pretty popular. I've been involved personally in a number of these in Africa, and my personal experience is they've worked very well. I mean, typically, depending on the terms of the contract, they can be set up on the basis of you nominate a local institute or international institution. Such, for example, for me as a quantum expert, the Royal Institute Chartered Surveyors provides a panel of experts, and you can offer under the contract a list of various institutions who you can request to appoint or propose a suitable expert. But ideally, from my experience, it's better in the situation where the panel of experts, so experts in fields of delay, quantum, technical experts and contracts management, etc., are already nominated within the contract or proposed list of names, or provided the two parties can agree who those independent experts are. And then if a dispute does arise, these people are in a position to act in a fairly prompt manner to look at the dispute. Ideally, if it's a long-term project, these people can be kept advised of the progress of the project and therefore have good familiarization with the project. So when a dispute arises, they know the general circumstances of the project, and hopefully they have an opportunity to work together as a team of experts to deal with the dispute. Obviously, the experts that should be nominated are those that have good experience in the type of construction project or whatever project it is. And hopefully, if the people are nominated, they're available and they can deal with the dispute. Hopefully that dispute can be resolved in a fairly quick and hopefully suitable solution, which normally results in either, if the contractor is entitled to an extension of time or additional payments, that award can be made, or that decision, shall I say, can be made by the DAB, and that allows the project to continue. Then if either the contractor or the client is unhappy with the decision of the DAB, normally there is facility to challenge that decision, but normally only after the project's completed. So all in all, you have the right panel of experts. They can hopefully resolve the dispute between the contractor and the client, and allows the project to progress to its normal completion in the best way possible.
Okay, thank you, Trevor. So you say it's a useful, the expression fast track is maybe the wrong one, but in terms of it generally provides an answer relatively quickly, relatively inexpensively compared to arbitration. But even if a party doesn't like that answer, it still has the option to go to arbitration. But I guess in terms of a well-run DAB and parties that run use DABs effectively, quite often that will resolve the dispute there and then without the need for arbitration.
Exactly, yes.
Yeah, okay.
On experience, yeah.
Yeah, cool. Okay, obviously time's getting on. There's a couple of other questions I would like to just put to the panel. First of all, Dr. Ismail, in terms of obviously the Cairo Regional Centre for Commercial Arbitration, Rob has mentioned obviously it was high ranking in latest research. How, in your view, how does the regional centre assist disputing parties resolve disputes, and how do they, if like the role played by the institution administering contracts and disputes? Could you fairly briefly, I'm afraid, provide some comments on that?
Thank you very much. Regional centers like Corsica, abiding by best arbitration practice, can contribute with the notable institutions such as the ICC and the LCIA to administer international and domestic construction arbitration. CERSICA is not an Egyptian center. It is an international organization, a non-governmental organization established under the auspices of the Asian African Legal Consultative Organization, ALCO, which has established CERSICA in 1979, so 42 years ago, by virtue of an international agreement with the Arab Republic of Egypt. CERSICA is frequently chosen by the parties, and including in FIDIC contracts, by changing the particular conditions from ICC to CERSICA for several reasons, because CERSICA applies the UNCITRAL rules with very minor modifications due to its nature as an institution and an appointing authority. So Egyptian and international and regional parties are familiar with UNCITRAL rules, which are not significantly different from the CERSICA rules. CERSICA is cost effective, and it has won the GAR award of the regional centers in 2019 and 2013, and one of the reasons its services compared to its cost. It's 41 or 42 years old, so we have a significant experience. We have administered more than 1,500 cases. I would say around 25% of the cases we have administered are construction cases. We have arbitrators appointed by virtue of party autonomy, mainly from various regions, from Europe, from Egypt, from North Africa, even from the sub-Saharan Africa, from Asia. We have parties from all over the world. We have at least 25% of our cases are international, and even more if we count Egyptian joint stock companies ultimately controlled by foreign shareholders. We are in the process of issuing dispute board rules, and this is very important and very much welcomed by companies doing projects in the region. And the dispute board rules of the CERSICA have been drafted and reviewed by a committee composed of experts of internationally renowned reputation, including, for example, Nail Bonni, Cyril Chern, Bernardo Cremades, Aisha Nadar, who is with us today, Ahmed Fathi Wali, Henry Masunda from FIDIC and Zambia, Ziyong Li from China. So from all over the world, the best practitioners of dispute boards. We have also invested in technology, and our investments paid off during the pandemic. 78 hearings took place at CERSICA hearings facility in 2020, because we are an institution, we are also a hearing center. 11 were held entirely via video conference, 2 were held entirely via teleconference, 10 were held with partial remote and partial in-person attendance, while respecting social distancing guidelines of the CERSICA.
Okay, thank you, Dr. Ismail. It was very helpful. And obviously, you say direct people to your institution if they need guidance or instruction on arbitrations. Okay, again, just conscious of time, there's one more question I'd like to ask before we do have a question from our participant. But the question I'd like to put to Ibrahim in terms of arbitration, we know is intended to provide the final answer to disputes, but we know that sometimes enforcement of awards is needed because a party considers it has a right to object. In that respect, what are the practical hurdles that impact the enforceability of arbitral awards in Egypt?
Yeah, so we have to make a little bit of a distinction between foreign arbitral awards and Egyptian arbitral awards. We did a study about the enforcement. When we talk about the enforcement, we talk about it in different stages. We talk about like getting the exequatur and then getting the money. These are two different, and unfortunately, we are very good at like having like, the exequaturs getting like, issued by the court. That's the step that is done in a very arbitration friendly way. The other step, or the second step, is a little bit messy for different reasons, for bureaucratic reasons. Dr. Ismail is well aware of them. But it's mainly because of two things: the judicial fees for the cases. So as per the law, the judicial fees for annulment claims and enforcement claims should be unquantifiable. but we don't know why the Court of Appeals usually say that they are quantifiable, and then you have to go to the Court of Cassation to reverse the ruling. So this takes time, and that's the issue. Like that, you know, the courts might not understand nowadays that time means a lot to disputants. You know, time value of money concept is a well entrenched concept all over the world. And the other issue is that in order to start like collecting the money, you have to deposit a percentage of the award with the court like administration that is responsible for, like, you know, doing the seizure or, like, you know, attaching the assets, which is 2.5%. That's a lot. It's
it makes parties think twice about enforcement.
yeah, you get it afterwards. You get it afterwards, like when you get the money, but from the loser party. But it's still like an upfront cost that you have to pay in order to get the money. So it is a little bit not as friendly as the Court of Cassation and the Court of Appeal when they enforce the award itself. It's sort of something that is done by a different, like, you know, body in the judiciary system. If we talk about the courts themselves, when we talk about the exequaturs, we're talking about like several decisions in the past 3 or 4 years that have paved the way for making Egypt a very attractive and arbitration-friendly jurisdiction. For example, we have now, like, you know, several decisions that says that email arbitration agreements are valid, and even emails in judicial proceedings are valid. We have different decisions about like the estoppel principle and how, like, you know, a party cannot, like, you know, try and do guerrilla tactics. We even have decisions about trying to, like, you know, defy these guerrilla tactics and make it and make arbitration more like a streamlined process. So we have a very huge set of decisions that makes Egypt a really good place to go and have your arbitration take place in it. But I think we just need to work on this last part about the judicial fees and the enforcement or the execution fees that you have to pay in order to get your money, because this is very important to any party in all over the world.
Thank you, Ibrahim. Again, very useful insight. We are coming to the end of our time period, but we've covered some very interesting issues and questions that we know could, you say, be discussed and talked about in more detail. But now just dealing with, we've actually got 4 questions from participants, all going back to the first question to do with time bars, so obviously quite a topical issue. Without going through each of the questions, effectively there's one question about how notice provisions in FIDIC 2017 allow some flexibility about time bars, and obviously the further notices of whether you've satisfied a time bar or not, but also allowing the DAB to set aside a time bar in certain circumstances. So there's a question there that what's the panel's view on effectively, is that good or bad? And the second one is more to do with employers' claims as to whether time bars can be applied to employers' claims. So maybe who would like to deal with the first one in terms of FIDIC 2017? Just some quick comments on whether that's a good or bad approach to providing some latitude to relaxing time bar requirements in certain circumstances.
Well,
Rob, do you want to take that one? Or
I was just going to quickly say, I mean, a lot of weight's been added, particularly in Europe, to this OHL against the government of Gibraltar case. But my reading of that case, the judge in that decision was quite lenient about the fact that notices hadn't been issued. But I think that's overshadowed by the fact that the contract was further complicated by some fairly substantial variations, etc. So a lot of people use that case law as being a good guide, but I have my questions to raise about it. But for in terms of time barring, it's also, for me, it's when the event occurred and when you're aware that it's going to have an impact on your project can often become, shall we say, a less well-defined point in time. And if you are a contractor who can use that argument well, then I think you can try and at least extend the time beyond the strict 28 days. That is my general opinion.
Okay, thanks, Trevor. In terms of the employer's claims, this has got a particular civil law perspective to it. So I don't know whether Dr. Ismail or Ibrahim want to deal with this. So I'll read the question as it's stated. It says, what is your advice to an employer who submitted the NOC beyond the 28 days? Should we still consider his claim as time barred? And is it an obligation de moyen or an obligation de resultat? Pardon my French.
So here it's pertaining to the employer's obligation to submit within 28 days, not the contractor.
Yeah, the question says the employer, but it's saying in terms of FIDIC, it's just as soon as reasonably practicable. But generally, does time bar apply
practicable.
Yeah, but I guess in terms of prior to FIDIC 2017, were employers' claims time barable?
Well, if the wording is as soon as practicable, but within 28 days, it would be an obligation de résultat. It will be because the 28 days would have to be respected. I don't have the provision in mind, of course, but it depends how is the wording of the provision. But if the wording of the provision doesn't leave a room to derogate from the time limit, then the time limit, in my view, should be respected.
Okay, thank you. And maybe one for you, Rob, the last one. Sorry to put you on the spot. In the specific clause, the time for making a claim, 28 days, this is going to be FIDIC 20.1, is tied to the time when the claimant became aware or should have become aware of the event. Your clause refers to the awareness of the employer. How can this awareness be proven?
I'm just trying to read the question.
Yeah.
Tied to when the claim
It's the last question. Yeah, how can you prove when a contractor ought to become aware of an event?
Well, there's obviously two things there. That there's if there is actual awareness, notification in some way, whether formal or otherwise, as to when a party ought to become aware of the event or clause, then I think that's got to be in the usual normal course of things, and not sort of covering their ears and eyes to the fact of something that's going on. I don't have a specific answer to that one. If anybody else can jump on.
No. Okay, well, I think we've run out of our allotted time, so I think it falls to me firstly to thank the four panelists who provided some very useful and insightful commentary on some quite topical issues in terms of claims, disputes, and resolving disputes. From my side, again, I'd like to thank everyone who's joined the call, and for the invitation, I think from all of us, for being able to contribute to this exciting initiative. So unless, Sakai, there's anything further you would like to say in concluding, that brings our session to an end.